Welcome to the program. My name is Marty Schenkman, and I'm here with two great organizations. Brian Jones, a financial planner in Connecticut, who I'm going to let introduce himself first. And then after that, Gus from the American Cancer Society, a wonderful organization. And I'm going to let Gus introduce himself and give a word or two for American Cancer Society. As we're getting started, there's a general disclaimer, and we're going to give you a lot of valuable information in the hour we have together. You can email Brian. Brian, why don't, after you introduce yourself, we neglected to put your email address here. Why don't we give everyone your email address, and they can email you questions or comments as we go, and you can read them at the end to me. Brian?
So first off, thank you everybody for joining us, and Marty, thank you for your wonderful help and assistance. I know it's going to be a great program. So for those attending, questions, please email them to Brian, B-R-I-A-N .Jones, J-O-N-E-S @nm.com. That's Brian.Jones@nm.com. And we're a planning, investment, and insurance agency doing concierge fee-based planning throughout Connecticut and 26 other states that we serve our clients on. And one of my associates, Dana Barrows, who's our estate and business planning specialist, will also be on at the end with questions for Marty. So Marty, thank you very much.
That's great. And if you or Dana want to chime in at any point, don't be shy to interrupt. I would ask all of you, though, to mute your phones while we go, just in case there's background noise, but don't hesitate to interrupt me. And just to get you excited, Brian, I was just on a phone call 5 minutes before I got on the webinar with an insurance consultant about a spousal lifetime access plan, our topic today, where we are selling two $4 million single life policies, one to be owned by each trust. And we're going to talk about that and the relevance of that to the planning as we go through our program. Gus, give us some good words on a wonderful organization, the American Cancer Society.
Sure. Thank you very much. And many, many thanks to everyone for being on the call today. My name is Gus Barisi, Director for Estate and Gift Planning, which I've proudly been serving now for over 20 years. We are so grateful, first of all, to Brian Jones and his wonderful group, the Jones Financial Group, which Brian, for over 20 years in this group, has been in charge of what we call our Legacy Plan Giving Group, highlighting the Waterbury and Southbury areas, respectively, in Connecticut, where we've done programs like this for advisors and also donors, but programs like this for advisors every single year, topics like 1031, topics of special needs trust, and they are our sponsor. We're forever grateful to Brian, a wonderful man, a wonderful professional volunteer for all these years. Also, many, many thanks to attorney Marty Schenkman, who has become an unbelievable great friend as well to American Cancer the past several years. Both of these gentlemen, my friends, donate their time and their gifts of talent to help us. At American Cancer Society, we've been around very quickly since 1913, and we've withstood a Great Depression and 2 world wars, and September 11, 2001, and now COVID-19, amongst other many historical events. And I just want to tell you that because cancer hasn't stopped, we haven't either, and we never will. And that is what we are here for. That is what we are about. That is what someone like myself, who handles Connecticut and Rhode Island, any advisors in Connecticut and Rhode Island, I'm more than happy to work with you on clients that do have a philanthropic interest. Maybe they want to make a bequest in a will, they want to do a CRAT, they want to do a CROT. And my friends, when you get a chance, you go on www.cancer.org, and you can find the respective director. They're all phenomenal throughout the states that will gladly help you with your client or clients that do have a philanthropic interest. I myself am a cancer survivor, kidney cancer, since 2016. Also, everyone was invited. That's part of our NPAN group. That's a National Professional Advisory Network. And all you need to do is go under cancer.org/NPAN. We strongly encourage you to join that, because you will get all the information about professional advisory seminars like this. Very briefly, my friends, you'll see there we're attacking cancer from every angle. There are activists, our breakthroughs, our communities, our direction. Very briefly, here in my home state of Connecticut, I'm proud to say we have over $12 million right now in research grants at Griffin, at Yale, and at UConn. So we continue to serve, but we cannot serve without the help of professionals such as Marty and such as Brian, who are involved with clients that do have the philanthropic interest. So it's just unbelievable, grateful. Thank you all for being part of the call. I don't want to take up too much of your time, but please remember, join the NPN group. It's a great, great group. We are here to help you. Also, very quickly, it's 1-800-ACS-2345, 1-800-ACS-2345, or www.cancer.org. Thank you so much.
Thank you, Gus. So let's jump into our program. So we're right now, it's for all intents and purposes, July of 2020. The election is in November. Please, none of the comments I'm making are intended or are meant to be political. It's really from a planning perspective. Gus, you should close off your okay, there you go. So the election very likely, if it goes Democrat, I'm not predicting it. It's a possibility. If Biden wins and the Democrats take control of the Senate, I would be shocked not to see major overhaul in terms of restrictions and changes to make the estate tax much harsher. And I thought that before, based on the Democratic platforms during the debates, based on the Sanders and Gomez tax bills proposed in the Senate and House in 2019, respectively, but also now with the massive bailouts that have occurred, it's going to be imperative for the government to raise more money. And there's only two ways to do it: issue debt, bonds, and raise taxes. And the only way you're going to raise money by taxing is to tax those with wealth. And Biden has talked about a capital gains tax on death. He's talked about raising the capital gains rate to perhaps as high as ordinary income to make them equal. I'm not sure what he's going to do with an estate tax. It's possible we have all of the above. What does that mean in terms of planning? What it means in terms of planning is clients should plan today and not wait for the election. I had an email with somebody this morning, not uncommon. He indicates that he understands that there's a need to plan, but he's going to think about it. And I emailed him back, think about it as you wish, but keep in mind that as the year goes on, and if any of you practice in 2012, you know exactly what I'm talking about. As the year goes on, it's going to get harder and harder to get anyone to do the planning. In 2012, when we thought that January 1, 2013, the exemption was going to drop from 5 million inflation adjusted to 1 million, it became a tidal wave. I know in my practice, we stopped taking new clients, I think from memory, in September 1, Labor Day. We stopped taking new clients because we had such a backlog. We were just afraid we wouldn't get it all done. When you started calling appraisers in September and October of 2012, if you were lucky, they would issue you a number and give you the report sometime in February or March of the following year. We're going to have that or worse potentially as we get later in the year. So if clients choose not to move soon, they may not find advisors to be able to respond to them. You need to keep that in mind. So if you're an estate planning attorney or an accountant, financial advisor, and you're doing planning with clients, if those clients don't move quickly, you may not be able to get an appraisal of a family business in order to really do the planning the way you want after a couple months from now. So it's really important to convey to all clients that they need to plan and they need to move quickly. What is the main thing they need to do? They need to use that exemption, because the Democrats have proposed that it drop to 1 million for gift tax purposes and a 3.5 million estate tax exemption. But a 1 million gift exemption, think of what that means. And we're going to talk more about it. If you have physician clients, they want to do asset protection. How do I know? Because every physician, including my wife, always wants to talk about asset protection. But if there's $1 million cap on it, most of your physician clients that are not even focused on estate tax, perhaps nearly as much as asset protection, malpractice protection, they're going to be in a very difficult position to move assets. I had somebody I was speaking to late last week, is getting married, wanted to do premarital planning. We talked about setting up a self-settled trust because right now he's single, he doesn't have a spouse. So the Slat topic we're going to talk about today doesn't work for him. And we talked about him funding a self-settled trust. He also got back to me. He's going to wait and think about it because they've deferred the marriage because of COVID. Well, but it may be too late to plan if he doesn't move. So we want to use exemption. On slide 7, asset protection is important for every client. It's not just the surgeon clients, the doctor clients that are concerned. Everybody should be concerned. If you're on this call and you're a professional advisor, you should be concerned. Why? Because we live in an incredibly litigious society, and that's not going to change. I'm not going to talk about non-grantor trusts that may provide income tax benefits. For those of you, and I'm assuming it's many of you who are in Connecticut, if you hadn't noticed, Connecticut has a rather high tax rate. So setting up a trust in Nevada that's a non-grantor trust where the income's not being distributed back to Connecticut, you can avoid Connecticut, defer, maybe avoid forever Connecticut income tax on that income. Great topic, important to think about in the planning, but not our topic for today. Now, why is this such an important environment on slide 8? Values remain depressed. Now, the stock market has recovered. NASDAQ has hit a new high, which I'll leave this to Brian and his crew to decipher the market. I'm not going to comment. But I think if you look a little deeper under the hood of the market, what you're going to find is that tech stocks that are excelling in this current COVID environment are doing phenomenally well. Delivery companies and so on, but an awful lot of stocks are still very depressed. So you have lots of clients that have lots of assets in the market that still may be dramatically lower than they were a few months ago. For family businesses, for real estate, if you have someone that owns a shopping center, those values may be significantly depressed. And hopefully as we climb out of COVID at some point, those values would come back. So planning now with depressed values is a great way to leverage wealth out of the estate. Interest rates are at historic lows, which makes a lot of planning techniques not a simple gift, but sale transactions, grats, and other techniques, which we'll only have very limited time, if any, to talk about, uniquely valuable in a low interest environment. We've already talked about how the deficit makes it almost imperative for the government to raise taxes to pay for the bailouts that have occurred. Now, top of slide 9. The first word on slide 9 is the single most important word for 2020 for planning: access. And here's why. If you have a client worth hundreds of millions of dollars, they need to leverage as much wealth out of their estate as fast as they can before the rules change. If you have a client worth $1 million, they're probably going to be reticent to do much planning. And even under the harshest Democratic proposals, it's unlikely they're going to face an estate tax. But for the clients from 3-4 million, and again, think of a doctor worried about malpractice. If she wants to transfer a couple million out of her estate and there's only going to be a $1 million exemption, she's going to be prevented from doing it. So once you get to, let's call it $2, $3, $4 million on the low end to perhaps 30 or 40 million on the high end, which is the large swath of most clients, those clients must preserve access to money they transfer. We saw lots of really, and I'm going to use a harsh word, dumb, unthought out planning in 2012. Gee, the exemption may go from 5 million to 1 million. And what a lot of people did is they went to estate planners and they set up trusts for children and grandchildren. They made gifts, and yes, they effectively got assets out of their estate. Why am I calling that planning not so smart? Because if the client was worth $20 million and husband and wife each gave away 5 million, they gave away half their net worth and they had no access to it because it was in a trust for kids. What if they need money? The last thing, without talking to any of your clients, I will guarantee you one of the last things any client ever wants to do is go to their children and ask their children for money. We have some echoes and feedback. Please mute your line. Everybody make sure your line is muted. I'm going to pause for a second and try to mute them here. Yeah, Brian, I muted you. I think that was your line. So nobody wants to go to a kid and ask their kid for a handout. You got to make sure that clients have access. And our topic today of Slat, Spousal Lifetime Access Trust, does exactly that. We want to use exemption. We want to protect assets. And oh, by the way, another thing the Democrats have talked about, and I'm not being political, I just want to set the stage from a tax perspective, is a wealth tax. We can't tell our clients whether or not a wealth tax will be avoided by shifting assets into an irrevocable trust today. But if those assets are grandfathered under the new law, it very well may be that those assets will avoid a wealth tax. So it seems to me that the prudent thing to do right now is to shift assets out of the estate into appropriate irrevocable trusts that preserve access, use exemption, and using exemption means these so-called incomplete trusts will not accomplish the goal. GRATs will not accomplish the goal. We're not going to talk about GRATs today, but suffice it to say and have on your radar, if a client hasn't used their exemption, I'm not sure why you'd be using a GRAT. First, use the exemption. Now, the key is access. How do you get access? Let me take a quick overview. We're on slide 11 and tell you what we're going to do. We're going to talk about how for married couples using spousal lifetime access trusts, or SLATs, the acronym Spousal Lifetime Access Trust, is probably a default plan that you may want to use as the starting point for planning. If your client is single, similar concepts can be used with a self-settled trust. And oh, by the way, in Connecticut was the 18th or 19th state to adopt self-settled trust legislation. I think it was June 2019, but definitely the summer of last year, Connecticut adopted a new uniform trust code, which includes self-settled trust legislation, which became effective January 1 this year. Self-settled trust is a trust. I can set up a trust in Connecticut, name myself as a beneficiary, and I can still have access to the money, and it's out of my estate, and my creditors can't reach it. So that's like the cat's meow of planning. Why are we talking about slats? My suggestion and belief is that a slat is a good foundation or chassis onto which to build the plan and has less risk than a self-settled trust, which is not respected by a lot of states and may be harder to administer. So that if you start with a slat, we can look at self-settled trust as well. Connecticut gives you great options. And if we have time, we're going to talk about how to integrate a self-settled trust or domestic asset protection trust, or DAPT, into slat planning. We're going to talk about how you structure the slats. That's really important. The example that I gave Brian when we started of a client I was just talking to about buying life insurance on each client's life in the respective slat is something that's important to understand. If you're an attorney or an accountant doing this planning, you want either the wealth advisor or the accountant to do forecasts to see financial models to show what the client's wealth situation will look like down the road. You want to make sure that they don't run out of money. And we're going to talk about that because that's critical. Too many people think, and clients in particular, which is why we all collectively have to educate the clients, think that you're banging out a form document and that's the plan. That is not a plan. That's the document. And even if you can use a form document, which I'm going to suggest, unless you tailor it to the client, you're not getting the result you want. The planning is critical, and that's separate and apart and should precede the document. We're going to talk about that. To the extent we have time, we're going to talk about some of the ancillary planning, which is critical. And I'm going to give you an example. If I have a client making a large multi-million-dollar transfer, I want lien and judgment searches done for the client. I want a balance sheet signed by the client. I want a solvency affidavit. It's not required, to my knowledge, in any state. Some states that have self-settled trust require a solvency affidavit. Many don't. But why do I do that? Because I want to make sure it's eminently clear that the client has the financial wherewithal to give the money away. I don't want a creditor to come later and say it was a fraudulent conveyance because they couldn't afford to give it away. They knew they were defrauding or hurting me as a creditor. There's some sample materials in the PowerPoint with some sample clauses. Now, what's a slat? I'm sure all of you know it, so we'll just go through it quickly, but I want to set the stage to make sure it's really clear what we're talking about. And you know what? I'll use myself as an example, because my wife and I have slats, and it's the core of our planning for all the reasons we talked about. We have access to 100% of the money we've given away. We have creditor protection. My wife is a physician. I'm an estate planner. We're both concerned about liability just because of the risky nature of professions. And slats are how we did it. I set up a spousal lifetime access trust in Alaska for my wife and all my descendants, children and grandchildren. My wife set up a similar but intentionally different trust for me in Nevada. And I'll tell you why later. We use different states. We have to make the trust different, because if the trusts are too similar, there's a concept called the reciprocal trust doctrine that courts or creditors or the IRS can use to unravel the planning. So you intentionally build in differences. That's why I put them in different states with different trust companies. Now that Connecticut has a self-settled trust statute, Connecticut is one of the favorable states to consider for this planning. Perhaps You have one in the home state of Connecticut and do another trust in a different jurisdiction like Alaska or Nevada or South Dakota that have been around for a long time with favorable legislation. To the extent you can create, excuse me, sorry, forgive me, to the extent you can create trusts at different times, that's good. To the extent you can fund them with different assets, that's good. Lots of our clients only have marketable securities if they don't have a business, so you can only put securities in them. There's no way to really differentiate it. Other clients may have investment real estate or a family business that can primarily fund one slat and use marketables in the other. That's a great differentiation. Another thing that you can do is fund them at different times. So let's say you do the wife's trust in July, make the husband wait until September and then do his trust in September. So they're pursuant to different plans and funded at different times. Slide 13 goes through some of the other things you can use to differentiate the trust. And again, it's critical that you differentiate the trusts because otherwise they could be pierced by the IRS on a tax audit or a creditor seeking to attack them. Now, one of the common things that's used to differentiate trusts are different powers of appointment, different rights to access, and so on. There's a detailed checklist that we're going to come to, but not spend time on because we won't have the time. But I've given you a lot of the common differentiations. Crummy powers could be included in one and not the other. I use document generation software to do this work. I think if you're an attorney and you're drafting, you'll find, especially if this becomes a major crunch as 2020 starts to get near the election and near year end, and a tidal wave of clients becomes concerned that there could be a Democratic shift in control in Washington accompanied by massive harshening of the estate tax. If you're not using document generation software, I suggest that you give some thought to it so you can get it up and running and get behind the learning curve, get it behind you before the year-end crunch that's, I think, is for sure coming. And by the way, as I said in the bottom of slide 14, we do all this remotely because of COVID. Our office is really not open, and we work remotely and do all of this there. Now, you can keep in mind on slide 15 and 16, slats can be used for other relatives. They're not only for spouses. We've just used that as the example. So this applies to a lot more clients. Now, what you want to think about is, let's take a look on slide 18. And I'm sure you're all familiar with this, but there's a really important point to make. We've all set up life insurance trusts. We've set up dynastic trusts, trusts for grandchildren, trusts for children. Doctors have come to us and other clients and wanted asset protection trusts. We've used various variations of domestic asset protection trusts. All of this can be built into the SLAT. So if I set up my spousal lifetime access trust for my wife and descendants, I only have to appoint an insurance trustee and put in some insurance provisions. With document generation software, it's a click of a couple buttons. And that SLAT can not only hold assets to get them out of my estate and preserve access to them, it can also hold life insurance. Now, Brian, think of how exciting it is if you're trying to help a client get comfortable with an insurance plan. They don't need crummy powers because the trust will have enough assets. So they don't have to make gifts annually. They don't have to do crummy powers. They don't need another trust. Sorry, lawyers. But you can do it all in one trust. It makes it incredibly simple. And the beauty of insurance being combined with a SLAT, let me explain. If I set up a trust for my wife and descendants, I can indirectly access assets in that trust through my wife. What do I mean? Let's say my wife decides that she wants a distribution to pay for living expenses. We're married, I'm living in the same house. If she gets a distribution from the trust I created, because I'm not a beneficiary, spousal lifetime access, not a self-settled trust, I benefit indirectly from the money she's withdrawn and used. If she wants to go on vacation, presuming I've behaved myself, she may take me along on that vacation. Although I'm not sure if we're going to get on a cruise ship in the near future, maybe never. But the point is, I can indirectly benefit. God forbid my wife dies prematurely. I have a gap because I can't get at the assets in her trust. And I'm going to tell you why that's not true. But let's say we want to be conservative. Many clients do. You're asking clients to part with millions and millions of dollars to get good asset protection, use up exemption before the laws change. They want to know they're not going to run out of money. If my wife's trust that benefits me bought $1 million term policy, just for argument's sake, a 10-year short-term policy. I'm 63. So by age 73, do I now have enough money to live if she outlives the 10-year term? If she dies before the 10-year term, there's another $1 million in the hopper for me. The amount and nature of insurance, whether it's term or permanent, should come from the financial analysis done of what happens if there's a premature death, let's say the next year for either spouse. And that's how you very conservatively can layer on insurance. So when you combine insurance with the slat, you virtually have assured that no matter what happens, death, spending, market performance, you have enough money between the insurance and the slat with your financial modeling to assure that you can protect each spouse. That is what's going to give the clients the comfort to proceed. Now, I've seen attorneys create trust for children, trust for grandchildren, separate insurance trust. You're going to have a half a dozen trusts or more for a single client. You can have one slat, or if you have them for both clients, two. All these trusts can be embodied in the same thing. There's no reason I have in my slat, my children and grandchildren are beneficiaries. Why should I set up a separate trust for each of them? It's not only more legal fees, it's an accounting fee every year for another tax return. It's the complexity. It's the hassles of having 7 or 8 different investment buckets instead of 1 or 2. You can greatly simplify client planning. And oftentimes when I have clients that have a lot of these trusts out there, they're amazed to see how much simpler we can make it. We need.
So Marty, just a quick question. Are there any spousal situations which the SLAT does not work? Non-residents, U.S. citizens, or any other special circumstances that would need additional planning besides the SLAT?
I haven't thought through the non-resident, so I'm gonna take a rain check on that. If you have a non-citizen, non-resident that's a beneficiary, I'm not sure it changes the trust. If you have a non-citizen trustee or power holder, you could have an issue depending on the powers they held of having a foreign trust, which makes more complex reporting. One of the places that you have issues with slats is in second, third, or fourth or later marriages. If it's a first spouse situation, the spouses tend to be more comfortable. But, there's another solution to some of the spousal issues. And again, this will vary by client, which is why you want the advisory team, the accountant, the wealth advisor, and the attorney all talking to the client to make sure we ferret this all out. If the client is concerned, what happens if there's a divorce? What happens? My wife dies, my spouse, my husband, my wife, my spouse dies prematurely. You can use a concept called a floating spouse clause. So the floating spouse clause says whoever I'm married to at any particular time is a beneficiary. So if the person I'm married to today gets divorced, they're no longer a beneficiary. And that works in a lot of cases to get clients in second and later marriages comfortable with the planning. The other thing is, if my spouse dies prematurely, insurance is absolutely an answer where people are insurable, and it's a very simple answer. But another approach is to use a floating spouse clause. So if my spouse died and I remarry, my new spouse could be a beneficiary, and I could again gain access through that. So lots of options, lots of options. Keep in mind on slide 19, if I put assets in a SLAT, and then I die under current law, I'm not getting a basis step up on those assets. You can swap them back in, but somebody's got to pay attention to exercising those swap powers, and too often that's not done. Keep in mind, Biden has suggested a capital gains on death and loss of basis step up as possibilities. So that may no longer be even an issue to think about. But we can adapt slats to address a lot of these different scenarios. Now, another thing to consider, slide 20, the third bullet point. When I die, my slat is no longer a grantor trust. As a grantor trust, the income is taxed to me, which permits me to swap assets in and out. When it becomes a non-grantor trust, if my slat is in Alaska, which is where mine is, if we don't remit money to anybody residing in Connecticut, we avoid the high Connecticut income tax because there's no Alaskan income tax on a trust in Alaska. Depending where the other beneficiaries live, the trustee can sprinkle money out to the beneficiaries each year, depending on state and federal tax brackets, and it's an incredible tool for minimizing overall family income taxes, state and federal potentially. So lots of interesting planning that can be done. We've talked about basis maximization and swap powers. Top at slide 22. One of the reasons, and I know I'm repeating myself, but it's really important. One of the reasons it's so important to make sure that the accountant or the financial advisor does financial modeling. Some accountants do, in my experience, many don't. So then you bring in the wealth advisor. In many cases, the wealth advisor may lead that charge. But the point is, as an estate planning attorney, I'm not doing a forecast. It's not my forte. I don't have the software. And a guy like Brian may do them multiple times a day. I can't remember the last time I did one. You want to make sure you don't overlook this really critical concept called longevity. If a client lives to age 100 or more, will they have enough money? So it's not just enough for the client to say, yeah, I got enough money if I put $4 million in that slat. You want to look at some numbers, because then you can go through the what if scenarios. Then you can show the client the need for insurance if there is a need. And if so, what type of insurance? Term, how many years, permanent because it's long term. What assumptions are going into the models. There is an attorney in California being sued because the client claims the attorney didn't do financial modeling, and I don't really know any attorneys that do that, frankly. And as a result, she put too much money into the irrevocable trust that the attorney set up. Well, I think it's a little unfair, because the bottom line answer is this should be a collaborative team effort. The wealth advisor, possibly the accountant, should have done the modeling, not the attorney's job. And the client was actually upset that the plan succeeded so well. Let's talk about some other benefits. So you have asset protection. We've talked about that. You can design a slat to include an institutional trustee. I like including institutions. I think it makes it safer from the standpoint of lawsuit protection, from tax protection if there's an audit. Uncle Joe and Aunt Jane as trustees tend to do anything that you want. If your client calls up their brother and says, give me a distribution, they give it to them. There's no paperwork, there's no thought, there's no process. Now, if you have an independent financial advisor, and many of our clients do, and they want to continue to work with them, no problem. You pick a pure administrative trustee. You don't have to hire a trust company that's going to be competitive with and create friction with the existing planning team. There's tons of top quality, very inexpensive institutional trustees that are pure administrative trustees. If your client owns a family business or real estate holdings, they don't want an institution in there charging them a percentage of assets to manage a business that they're running themselves. Answer, you do what's called a directed trust. You can do it in Connecticut, where you appoint an investment advisor to be in charge of the investments for the trust. You get an administrative trustee and pay them a fairly a moderate flat fee each year to serve as trustee. I like incorporating the bottom bullet point, a trust protector. I like incorporating a trust protector so that it gives more flexibility to change as time goes on, or if there's a bad actor that gets involved, we can remove them. After the client's death, you have the flexibility to monitor distributions and so on to minimize state and federal taxes, which we've talked about it. I don't know the number today on slide 26, but I think it's maybe 17 states still have an estate tax. It remains to be seen if they lower the federal exemption to 3.5 million and 1 million for gift tax purposes, what the states are going to do, right? In Connecticut, I think it's a $2 million gift exemption. The estate tax is kind of odd, but if clients face a $3.5 million federal exemption, I wonder if states will bring back estate taxes. The other thing that's very concerning, all states have been hammered financially, right? 3-4 months so far of dramatically reduced revenues, and we don't know how long it's going to go on. If the reopening is phased, in percentages, I'm hearing of a lot of companies that are going to work remotely until the end of the year. The revenues of every state are going to be impacted. Will states start looking again because they have no choice at reinvigorating an estate tax? And by the way, if a year from now 40 states have an estate tax, there's no reason Connecticut can't retreat from some of the leniency in their estate tax and make it harsher again. I think the problem was that if everyone could just pick up and move to Florida, for example, and avoid the estate tax in Connecticut, it was kind of risky for Connecticut to push too hard. They could push enough to get revenue, but they couldn't push too hard because then people would flee the state. Well, if 40 states now have a year from now estate taxes because the revenue issues caused by COVID, it could change the whole situation. We've kind of covered all
Marty,
this.
as you're moving along, I'll just remind people, if they do have questions, it's probably going to be best for them to text them to me, and anybody can write down my cell number that they could text to. That's 203-578-5326. So if you do have any questions for Marty as we go along, 203-578-5326, just text your questions and we'll read that as we go along. Thank you, Marty.
Thank you, Brian. The reason for doing that, everyone, I can't answer questions while I'm speaking. It's too hard, but Brian will be my catcher and field them. And I think Dana from his office may jump on later and we'll answer questions at the end. Let's change gears, because hopefully what we've done is set the stage that nobody knows what the election is going to do. If there's a Democratic victory, and maybe even if not, just given the fiscal pressures of the bailouts, it's certainly likely to see an increase in state tax, capital gains taxes. And so one of the things we can proactively tell clients to do right now, move assets out of your estate into irrevocable trust, use up that high exemption. And I apologize, I don't think I said the amount earlier, but I'm sure you all know it. It's 11.58 million. So about 23 and change $million for a couple. So hopefully at a $23 million exemption level, a large swath of your clients can move out as much money as they want to. But the key to that is preserving access for them in doing it. So if you can show the client that they can have access, you can show them financial models to show that they have plenty of money to live on. And if there's a gap, use insurance or other techniques, and we'll talk about some before we end, to get them access so that they can live on their money comfortably. That is a phenomenal planning tool. It's also great asset protection. And I apologize, I should have said at the inception of the presentation, when I said that we live in a very litigious society, think about the impact of COVID. How many lawsuits are going to stem from COVID? If you have an office and you reopen your office and somebody gets sick, are they going to sue you? There's really, the law on this is a little sparse, and there's great uncertainty. So there's no doubt that COVID creates risks. Recessions always create risk. And I was talking to a litigator colleague of mine who said when the economy gets bad, business for him gets better, because perhaps more people are looking for that lawsuit because A, they don't have enough other work to do or they're out of work, and B, they're looking for any source of cash that they can find. So consider all that. Now let's talk about some structural things. Now, the example here, I'm going to try to paraphrase it, but it's really important. And let me just give you the top side overview. Not every client needs to set up a non-reciprocal spousal lifetime access trust. I set up a trust for my wife. She set up a trust for me. We're each a beneficiary of the other's trust. We can access 100% of our money, yet it's out of our estate and I believe protected from creditors. That's a great default plan to start with. And I always start by discussing that with clients so they understand if spouse one sets up a trust for spouse two is a beneficiary of that trust. If spouse two sets up a trust for spouse one's a beneficiary of that trust. 100 cents on the dollar, they can indirectly access together. But do you need two trusts in all cases? The answer is absolutely not. Where you definitely may not want to have two trusts is where you have clients whose estates are under, let's say, the $11.58 million exemption. And this is an example of why. So let me just go through it and follow along on slide 33. Husband and wife have a combined estate, and I used husband and wife rather than spouses. I just think it just makes it easier to follow for this, so forgive me. 16 million, and they're willing to make a total of $8 million of gifts. They sat down with their financial advisor and they decided that's the most they're going to transfer. Maybe they could have done more, but that's the most they're willing to do. So the default initial answer is husband puts $4 million in a trust, a slat for the wife. Wife puts $4 million in a slat for the husband. They've each used up $4 million for a total of $8 million of their exemption. Well, that sounds good because if the exemption drops, they've used up a good chunk of it. However, look at what's happened. If instead, just say husband set up a slat for wife and put $8 million in it, if the exemption drops to $3.5 million, which was the Democratic proposal that we've seen repeatedly, under the plan that I gave you first, where they each put 4 million in, they have 0 exemption left when the law changes. But if one spouse, the husband, used 8 million of his exemption in a slat for the wife, wife still has 3.5 million exemption under the new law. They have 3.5 million of exemption they would not have had under the first plan, and one less trust. So it's half the cost, half the headaches, and half the hassles. They may be better off doing one trust instead of doing 2 trusts. But now here's the key. You got to make sure in a plan like that, while it's simpler and cheaper and clients may jump on it because, oh boy, I just cut my legal fees in half. That should not be the sole determinant of a plan, is the legal fees. You want the results. They need to go through some financial modeling and make sure husband has enough money. Maybe what you do is husband uses up 8 million of his exemption, and maybe based on some financial modeling, we determine that if there's a $3 million term policy on wife for 15 years, so long as wife lives 15 years, so husband has indirect access for 15 years, based on his life expectancy 15 years from now, he has plenty of money in his own right. Maybe that simple insurance policy saves the day and the plan works. There's other approaches we're going to talk about, but the take-home point is, even though I like to start the discussion with 2 spousal lifetime access trusts, in reality, may be better off doing 1. And I go through that and illustrate the same more here, but I've tried to shortcut it just because of time. But you should go back if that's not clear to you and look at those examples, because they'll drive that home. Now, here's just some
Marty,
thoughts.
we've gotten several
Sure.
questions about the slides. So if you would just explain at the end the people about how they'll have access to the slides, because you're going through a lot of great material, but many people have asked to be able to review it afterwards. So if you'd mention that, sir.
Okay, couple of things. First of all, Brian has the PowerPoint, so you can always email Brian. He'll send you everything. And Brian, if you remind me after, and I won't be able to get to it till tonight, if you email me, I'll send you at least 2 or 3, maybe more articles that I've done on slats, and you can make all of that available to anybody that contacts you. So email Brian, and Brian, just say your email address real quick.
Brian, BRIAN .Jones, JONES @NM.com. And I believe we're capturing all the people who signed up. So at the end, we should be able to send those. But if people have specific questions, text them to 203-578-5326, and then send me an email, and we'll make Marty's been very generous to make the whole email slide deck available.
And the slide deck is on the control panel that you have on your screen. So if you click on the little tab called handouts, it should open up and you can download the PowerPoint from there. We'll also make available to Brian a recording of the webinar, and you can access it probably if he can put it on his website. If not, I'll post it to my website, Schenkman Law, but email Brian and he'll fix you up. But it is on the console. You can get it now, and Brian will get it to you. So here's some thoughts on slide 36. When you draft a slat, encourage a broad class of beneficiaries, not just the spouse. Now, you may need to differentiate it between the 2 trusts, so husband's trust, say, is different than wife's. But the reason I like a broad class of beneficiaries is the following. If I name just my spouse, and my spouse is in a higher tax bracket than the kids, I've reduced my income tax planning opportunities. If I name spouse, children, and grandchildren, it gives me the ability to have the trustee sprinkle income to whoever's in the lower bracket. And let's say one of the kids becomes a basket weaver living in Florida where there's no state income tax. They're in a lower federal bracket and have no state income tax. You know, maybe you favor distributions to that child in order to save overall income tax to the family rather than distributing to somebody in Connecticut where it's a high tax bracket. So consider a broad class of beneficiaries if it's appropriate for the client's wishes and not necessary to restrict to differentiate the trusts. I like to have the broadest class I can because it gives you the most flexibility. Think about asset protection. My wife is a physician. If she's subject to a malpractice claim, I certainly don't want to make distributions to her to enrich her claimant. But if I only have her as a beneficiary, there's no other way to get at it. If I have children and grandchildren as beneficiaries, I can distribute money out to them and my wife's malpractice claimants can't possibly make an argument that they're entitled to anything. Keep in mind the net investment income tax. I'll leave that for the CPAs on the call. We won't have a time. I like to include in every slat, unless there's a reason not to, by default, insurance provisions, and name a separate insurance trustee so we can always add insurance. You don't need it, you don't bother, but click of a couple buttons with document generation software, and I now have a really robust insurance trust. Consider whether a floating spouse clause. Keep in mind longevity, the duration of marriages. There's a lot of our clients that even in their 80s, either a spouse passes away or there's divorces. It gives you much more flexibility. Hang on. I like to use trust protectors in every irrevocable trust to build in more flexibility. A trust protector can be in a fiduciary, a non-fiduciary position under the terms of the agreement. It can give the person the right to fire and remove and replace an institutional trustee or any trustee, correct scrivener's errors, change situs and governing law, and other things. Be careful because the word trust protector is used to mean a whole bunch of things, and you really need to differentiate it. So for example, if I give somebody the power to loan me as the settlor money, I don't want that person also holding the power to replace a trustee. My suggestion. On slide 38 is a list of some of the powers, and 39 that you could give a trust protector. Great way to build flexibility in. You may want to include charitable beneficiaries. Even though you can't in a grantor trust get any incremental benefit from contributions when the client dies, if the gross income of the trust can be allocated to qualified charities, the trust will get a deduction. Trusts aren't subject to the same standard deduction rules and limits that individuals are, so you may maximize that deduction. It's also valuable to have the flexibility of being able to give to charity. Now think for a minute. I set up a trust for my wife and descendants. I also add in the ability for the trustee to give to charity. I give X dollars a year to 5 of my favorite charities. I can't use trust money because I'm not a beneficiary to discharge my legal obligation to support. But if the beneficiaries say to the trustee, give to the American Cancer Society $10,000 in 2021, and they do so, then maybe I don't write out my personal check, the trust did. That's another indirect way I can access money to the trust. Spouse is a beneficiary, making charitable gifts to organizations I would have otherwise benefited, benefiting family members I would have benefited, loaning me money from my own trust, all legitimate ways I can retain access to a trust. Slide 41 is the loan provision I've talked about. This was historically used by practitioners to make a trust a grantor trust, and it still does. But think about it in the context of 2020 planning, where we have such a high exemption. And if I have access to that money, I'll put more money in the trust. The ability of a friend of mine, my college roommate, I name him in a non-fiduciary capacity to be able to loan me money without adequate security from the trust. He can loan me money anytime I want. Great way to get access to the money. Gives me more peace of mind, gives your clients more peace of mind setting up such a trust. So loan provision is a great tool. And here's a sample of one. We're going to skip the 38 power for causing estate inclusion. Slide 44, make sure you give an express provision to the trustee to decant or merge the trust into a new trust, so the trustee, without any hassles, can create a new, more modern administrative provisions for the trust. Swap powers are key. I put money in a trust, your client puts money in a trust, Brian invests it, it's worth 10 times what you paid for it a year from now. That's your guarantee, right, Brian? 10 times rate of return per year? So
neither stated nor implied, sir.
But if I want to bring that back in my estate to get a basis step up, I can do it. A swap power permits me to do that. People only think about swap powers from a tax perspective. We don't have a lot of time to talk about it, but let me give you just a great non-tax perspective. I set up a trust, a spousal lifetime access trust for my wife and descendants. I put the family business in the trust so it grows out of the estate. I got it valued at a low value today because of COVID and beat up the value, got the whole thing out of my estate. And you know what? The way I structure the trust today, my oldest son is kind of running the business. I'm going to leave the business to him or keep him in control under the terms of the trust. 5 years from now, I discovered that my youngest daughter is shining and she's
Right.
really taken over the business. And my oldest son is kind of more into playing golf. Well, maybe I want to change the terms. I can't so easily change the terms of an irrevocable trust, although decanting may suffice, maybe not in this context, but I can swap cash for the business, bring the business back into my name, put it into a new trust. Clients will love the flexibility. We're going to skip through some of that. Now, one of the ways that you differentiate trusts, and remember I said because of this concept called the reciprocal trust doctrine, if the trusts are too similar, creditors or the IRS could uncross the trust and destroy the plan. So for example, the absolute no-no of reciprocal trusts is I draft a trust for husband, and then I simply swap out husband's names for wife's name and have wife sign the same document. Not a good move. It's cheaper because it doesn't take very much time, but the trusts are now identical. If there's a lawsuit, wife's creditors may come and say, listen, wife and husband are in no different of a position because they're beneficiaries of trusts that are identical. You don't want to do that. One of the ways you differentiate the trust and build in and infuse flexibility into the trust are using what's called powers of appointment. So for example, I might give my spouse a limited power of appointment to determine how our descendants shall inherit. So if there's a special needs descendant she wants to shift more money to, she can do that. If the world of trust drafting and trust law is very different 20 years from now, she can exercise the power and maybe appoint it to our 5 kids in somewhat different trusts that are reflective of what current state-of-the-art trust drafting is. It adds tremendous flexibility. Having different types of powers of appointment in each trust can differentiate one spouse's trust from the other. So for example, in my wife's trust, she may have a lifetime limited power of appointment. I may not have such a power. That's a great significant difference between the trust, and I think it was the Levy case that specifically recognized that different limited powers of appointment can differentiate a trust. People use general powers of appointment to cause basis inclusion. So I give my mother-in-law the power to appoint trust assets to her estate. Arguably, that's a general power of appointment. We can't get into the details of it. But on my mother-in-law's death, all the assets in the trust I set up are included in her estate. Now, you got to be really careful, folks. Remember what we just said. Right now, the exemption is 11.58 million. The Democrats have talked about 3.5 million. If mother-in-law has a $3 million estate and we set up a trust with $5 million in it, oops, we've just triggered an estate tax on her death years before we die for no reason. So if those general powers were created to get basis and they assumed that the exemption would go higher year after year, you better fix those trusts really quickly because you could have a disaster on your hands. There's a sample optional general power on slide 54. On 55. Another approach is you give somebody the right. I'll give Brian the right to convert a limited power I give to my mother-in-law into a general power. That way she's got a power, but it doesn't cause estate inclusion unless Brian affirmatively acts. And he won't affirmatively act without a balance sheet and buttoning down what her assets are so that we know. I'm going to stop at the top of the hour and then we'll take some questions and chat for a few minutes. So just stick with us and we'll make sure you get all the materials. You can require the consent of another party before a power of appointment can be effective. Another way to have control over it. Now, we've already kind of talked about this, but you got to figure out in the plan. And I said in the beginning, if you recall, you know, clients may think you're just popping a form off of a form book for a slat. It ain't the case. But more important than even the form is the planning that goes and precedes the form. So you got to consider financially what happens if one of the spouses dies prematurely. And especially think about that in the context of the structure of the non-reciprocal slats. If husband and wife each set up a trust and put in $4 million each, like one of the examples we had, and one dies prematurely, the other surviving spouse still has $4 million they're a beneficiary of, plus whatever assets remained outside the slats. But if instead the client wants to save the money, and actually it's a better tax result in terms of exemption, and just have one spouse set up 8 million trust, that was our example, you got to make sure if the spouse that's the beneficiary dies prematurely, there's plenty of ways to get access for the surviving spouse. We talked about financial modeling. We talked about life insurance. We talked about the loan provision. Here's what let me do a DAPT and then a hybrid DAPT. A DAPT is a domestic asset protection trust, which is legal to do now in Connecticut. So I could set up a trust for my wife that I'm also a beneficiary of, and thereby, if she dies prematurely, I have full access to the money in the trust. Now, I suggested that many people viewed self-settled trusts as riskier, and you can't weigh it. It's, not 3 pounds riskier. There's no way to measure it than a spousal lifetime access trust. So maybe to be safer, I'm not going to be named an initial beneficiary of the trust, but I'm going to give Brian, who's my old buddy, the right to name any descendant of my grandparents as an additional beneficiary of the trust. The right that Brian has can add me back as a beneficiary. But Brian is not a trustee. He's not a fiduciary. You can't force him to do what's not required of him. And if somebody like a creditor goes to Brian and says, Brian, add Marty back so I can get the money, I'm his creditor, Brian's going to say, nope, not doing it. So it's not a self-settled trust until Brian acts. And I don't have to have Brian act as long as my wife is alive and I don't need the money. So that's a hybrid DAPT. And a SPAT is a special power of appointment trust. And let me illustrate that because it's a newer concept that's kind of intriguing. Instead of having Brian add me back as a beneficiary, because now it's a self-settled trust, which again works in Connecticut under the new law, I'm giving Brian the power to mandate the trustee make a distribution to me. I'm never added as a beneficiary. Trustee has no discretion to give me money. Brian says to the trustee, Alaska Trust Company, Peak Trust in Alaska, Peak, give Marty Shankman $100,000. They have to do it because the trust says they got to listen to Brian. I'm not a beneficiary. I'm just getting an optional discretionary distribution mandated by a non-fiduciary Brian. So those are ways to add in ways to get access. The next 4 slides, go through hybrid DAPs and SPATs in greater detail. Now, just as another point, slide 66. Again, I told you in the beginning, the key word for 2020 planning is access, because most clients from 2, 3, 4 million, where they're going to start this kind of planning, up to 30, 40 million, if they don't get access, if you can't get them comfortable that they can get at their money, they're not doing the planning. The more comfortable you get them, the more they may be willing to put into these trusts to safeguard their lifetime accumulation of wealth from what might be a much, much harsher estate tax if there's a change in power in Washington. Slide 66, I can have my Slat own a vacation home. I can indirectly use it if my wife, who's the beneficiary, goes there, if she takes me along with her. Income tax reimbursement. I can include in Connecticut and under many states, not all, the right for the trustee to make a discretionary, not mandatory, distribution to me to reimburse me for income tax I paid on income earned by the trust. Another 2 great ways to get access. So if you sum up everything we've talked about, there's lots of ways to get access. Now, the next set of slides, which I'm going to skip through, there's 6 of them, a laundry list of ways to make each trust look different. Now, we're really out of time, so let me summarize where we are, and then I'll tell you what the next topic is. So I think the starting point of discussions with clients for most advisors is, hey, client, if you're married, let's talk about non-reciprocal, meaning different, spousal lifetime access trust. So each spouse can get access to the other trust. Between the 2 of them, they have access to all the money they've moved out of their estate. Now, they got to administer these things right, because otherwise you can't have your cake and eat it too if you don't play by the rules. The biggest issue is access. So in addition to doing non-reciprocal slats, so each spouse is the beneficiary of the other, we talked about insurance, hybrid DAPs, SPATs, loan provisions, buying a vacation home in one of the trusts, tax reimbursements, lots of ways we can protect our clients. The heart of it, get your client to have a financial forecast done so they know where these numbers are going, and you can help assess more quantitatively, even if it's guesstimates, where they're going and what it means. Phenomenal planning tool. For single clients, you can craft on much of what we talked about using non-spousal beneficiaries. We talked about that. We're using a self-settled trust, and we've talked about that. And again, for those of you in Connecticut, which I assume is most of you, it's a phenomenal tool because you can do it right here in their home state. Now, all the concepts we just talked about can and should be applied to improving existing trusts. We're going to skip that. There's lots of ancillary planning. You can use entities to have further asset protection, discounts for estate planning purposes. Um, we can tie in and coordinate with GRATs. You can put swap power provisions and powers of attorney, and so on. So this is really a phenomenally powerful planning tool. I think the number one issue for all of us, or objective, should be educate clients that they got to start planning now, because as the year rolls on, and it's already July, July is like in a day or two. Once July hits, August, September, we're going to run out of time to finish the work when people start to panic. Oh my, the election is coming. The polls show Biden winning, which may or may not be conclusive at all. But clients may well panic and want to get this planning done before we end up with $1 million gift exemption. And again, it's not just super wealthy clients. One of the biggest problems I see is clients know that the current exemption is 11.58 million, and if they're only worth $8 million, they tune out the whole conversation. They can't afford to, because at an $8 million estate, they're not going to be able to do asset protection planning under the new law. At a $5 million estate, they may be hindered from doing asset protection under the new law. At a $10 million estate, they could have a massive estate tax if we have a $3.5 million exemption enacted. So we need to educate clients and get them to move forward. On slide 85, I have my email address, Brian's. If you need any of the materials, I'll make sure Brian has them all, and I think he does already, but I'll send him some articles. And Gus from the American Cancer Society's email is there as well. So thank you for joining us. If you can stick around, please don't hang up. Brian, do you have any questions, or is Dana on the call that we could talk about some of the points that we discussed for a few minutes?
Correct. So there are actually a couple questions that came in. The first thing, you were talking about a team concept, obviously, of making sure that there's a financial plan, that legal, accounting, trust advisors are all in there. But if people want to consult with you on specialty items, are you available to the professional community as a consultant, was one of the questions that came in.
I'm happy to consult. If a client has a long-term relationship with an attorney, I don't want to harm that relationship, and there's no reason that we can't work together. I do that all the time. But let me just jump on the point you made. I'm using a strong word on purpose, zealous believer in a collaborative team effort. As professionals, the best thing you can do to help protect yourself from lawsuits and claims is to have a collaborative team effort. If you're an attorney and you have a financial advisor, an accountant, an insurance consultant, sometimes it's the same person, sometimes it's different hats. Maybe you don't do corporate work, you have a corporate attorney. But if you get a team together, everyone on that team is going to catch something that somebody else didn't. And even if you're the most brilliant practitioner, and I don't know anyone that's the most brilliant practitioner that sees everything. Nobody can see everything. Clients have this funny tendency that if I'm working on a client with Brian, the client, I guarantee you, will tell Brian something they don't tell me. They'll tell Brian's colleague Dana something they don't tell Brian, and they're going to tell me something they don't tell either of them. I have no idea why clients do it. It just seems to be human nature. So when you have a team effort, you see things from different perspectives. Client gets a better result. The initial reaction of many clients, and it's foolish, oh my, all these people, it's going to cost me more money. No, usually it's going to cost you less and get you a better result. So definitely go team, and I'm happy to collaborate where it's feasible.
Super. So a couple of the questions came in. One is, how would you explain the concept of access to a client in the initial meeting?
I start off, that's why I like to start a discussion, even if they may only need one slat or one variant of a slat with a hybrid dapt or something else. I want to start by explaining what a spousal lifetime access trust is. And if each spouse does this for the other spouse, each spouse is a beneficiary of the other's trust, they start to see, okay, I'm a beneficiary of half the money we're giving away. I know I got access to that. If they can't live on that, and even if they can, I talk about loan provisions. That's a standard thing. I talk about a tax reimbursement provision. I explain that it's okay to buy a vacation home in the trust. I explain how you can put charities in. You cannot discharge a pledge that the client made, but they can certainly make distributions to charity. And there's all these other ways you can get access. If you have a financial model that shows, okay, if you move X dollars out of your estate, you can survive on what you have left. Here's how. You got them over the threshold right away. If you want to model, if you did a financial plan, Brian, And I say, okay, we did these 2 slats, set those buckets up. No big deal. You can do it. Now, let's say the client's looking a little concerned. I'll say, Brian, throw in a couple $1 million of insurance. Throw in a $2 million permanent policy. Let's see what that looks like. And you show the client the numbers. And through that sort of back and forth, the sensitivity analysis with the financial model, you can really illustrate to the client a lot of these techniques. And then you layer on those the right of a colleague or friend to loan them money, et cetera.
Great. Thank you. So a couple other questions came in. Actually, our estate and tax planning attorney, Dana, had a question. How do you get a sense or a feel of the health of a marriage when you're in a client fact-finding meeting?
Since this is recorded, I take the Fifth Amendment. You can't really do that. But, fundamental to a lot of the planning we do is the assumption that the marriage is stable and will continue. Now, is that a reasonable assumption? People often quote a 50% divorce rate, but that's really a misnomer. There is a book by Charles Murray, I think it's called Coming Apart, and it's really sort of a social study of America and wealth and things like that. But what I recall reading in his book was that among the wealthy, educated elite, which is most of the clients that most of the people on this call have, the divorce rate is half of what it is for the country as a whole, which is fascinating. And the growth area in divorce, which unfortunately may affect most of our clients, is what they call silver or gray divorce. Those over age 55, I think they refer to it as. But that's a discussion you have to have with the client, and certainly for attorneys, but perhaps for other professionals, you have to be very careful. I'm representing both of you guys. If you have any of these concerns, you each have to go out and consult a matrimonial attorney. I can't advise one of you against the other. But by the way, if you have a financial forecast, Brian, that shows that even if I put X dollars in a slat for my wife and she did the same, that if she died and I lost access to that trust, right, that I still have enough money to live on, I don't have to worry because I still have enough money to live on. So I think you need to deal with it. It's not a simple answer, and you have to be upfront with clients. And honestly, the clients have to make the decision. You're going to talk to them about the pros and cons. And when you raise the idea of a floating spouse clause, oftentimes you'll see very quickly how people feel about things. I've had some spouses get very upset about even the discussion of that, and we've kind of changed the topics because we can't pursue it.
So we have to, great responses. I appreciate that. That's all super impact from a career that you've built in a specialized area. So a couple other quick questions. How long, from a practical standpoint, have slats actually been around and been in existence? And then a couple other questions are coming across my screen after that.
Well, let's remove the excitement. I've used the acronym SLAT because just like ILIT, Irrevocable Life Insurance Trust, it kind of helps people know what we're talking about. But don't get hung up on the acronyms. Cobble together, and my view of what estate planning really should be, throw the acronyms out the window. Use the Lego concept. Brian, did you play Lego as a kid?
Of course.
Of course, I did too. I loved it. I call it the Lego concept of estate planning or trust drafting. I want to take the building blocks that work for that client, cobble them together, not get hung up on what form I have or don't have, or what acronym the client came to me asking about. If we want to be realistic about it, a SLAT is a fancy insurance trust. The traditional life insurance trust, I set up a trust for my wife and kids, right? I made a gift each year to the trust that did crummy powers and bought insurance on my life. The traditional life insurance trust is inadequate. We can do a much better job with modern trust planning. For example, why only name the kids and have the thing pay out at age 35? Why not have it go up as long as the rule against perpetuities permits? Why not have it for all future descendants? Why have the kids have to have it back in their estate or subject to their divorce? So we can start building a better trust model than the traditional life insurance trust. But the traditional life insurance trust was really a SLAT. We just usually never put more in it than $100 and each year's gift to fund the insurance premiums. The SLAT, if I simply add some insurance provisions and an insurance trustee, I can have a SLAT own insurance on my life, and it's much more robust and powerful because of all the creative planning we talked about for the last hour and 10 minutes or so. So a slat conceptually has been around for as long as an insurance trust has been around, which is an awfully long time. But that's why I think don't get hung up on the acronym or but rather focus on the building the Lego approach of what the client. And I think the Lego perspective, you'll find you're getting better results for your client. If advisor and the attorney is creating a trust and they keep talking about acronyms, make sure the building blocks your client needs are in there, because that's what's going to ultimately protect the client and give you the wherewithal, the ability to do the best job possible for your client.
Thank you. So you're talking about different assets. You talked about businesses and other flexibility. Walk us through a little bit if a client has a preponderance of their wealth in IRAs and how a SLAT would be a vehicle for an asset that's concentrated or it's inappropriate for. So
you can't transfer an IRA into a SLAT. You can't even transfer right now. It makes no sense to me, and it's unfortunate. An IRA into a revocable trust that you have complete control over, because the IRS's view is you're going to trigger the gain. So if you have a large IRA, what you might really be doing is build what sounds like a more traditional life insurance trust. But if you're going to do that, build it on the SLAT chassis that we talked about, so you have a more robust, sophisticated trust to better help your client. There's no reason that you don't have decanting provisions and trust protectors and dynastic provisions in the insurance trust. So it may be a robust SLAT, but you're not going to name IRA assets to it. What you want to do for IRAs, and that's a whole different program, and it needs to be talked about, because after the Secure Act, the government is shaking up all the planning. We used to live for the stretch IRA, and while that's still available for a spouse, disabled, or chronically ill beneficiary, most other beneficiaries can't get it. They're capped at amount of time for 10 years, the end of the 10th year after the death of the plan holder. So for Secure Act, for post-Secure Act IRA and retirement plan benefits, you may want to use an accumulation trust for asset protection, but then you got compressed trust income tax rates. You may want to tinker with the use of a NIMCRUT, a net income with makeup charitable remainder unit trust. A NIMCRUT is a cool technique for some. So if you have a large IRA, you got other things you have to explore. And by the way, if you got a large IRA, I'm not sure how you're going to use your exemption and safeguard yourself from the new tax law. You may just want to buy an insurance policy. I'd have to give some thought to it, because if you pull the money out now, you're going to pay an income tax today. What does that look like if you project forward losing a chunk of money today for income tax in order to plan with it? I'm not sure that. And by the way, IRAs are protected under most state laws from creditors anyhow. So why would you risk losing that? So IRAs are a different ball game, require different planning. And that's why the same concept with the Lego approach, and I don't mean to make it sound trite, I'm trying to do the opposite. You really got to pick what works for each client. You got to be very careful pulling a form out of a form book and having that as your default plan.
So Marty, you do a lot of public presentations, a lot of nationwide volunteer work for many organizations and foundations. You speak all over the U.S. at national seminars. We still have over 40 people still on the line. I'm sure, obviously, you've been very interested in what you're talking about today. Could you tell us a little bit more of some of the informational things that you have on your website, or other resources that you as a professional make available to our other centers of influence and practitioners?
Sure. I've always tried very, very hard to help colleagues because it just the right thing to do. And I will never forget when I started my practice working out of my basement without the pot to proverbially do you know what in. And I recall the disheartening disappointment of when I would reach out to, well-known successful practitioners and seek hand or a piece of advice on something, and the kind of responses that I got. God forbid somebody should ever share a form or a clause or a document, which this handout has lots in. So on schenkmanlaw.com, SHENKMANLAW, schenkmanlaw.com, there's a webinar tab. There's probably 50 webinars full of information. Most of them still have the handout information. They're recorded webinars, anywhere from 60 to 120 minutes on a whole range of topics. I've made a really concerted effort over the last 3 or 4 months to do, much more than I normally do, just trying to help out colleagues. There's a lot of stuff on, using technology to work remotely, especially as an estate planner. And it works for a lot of the planning works for allied professionals as well. There's a 2-hour deep dive into slats. There's a webinar on the Secure Act and the use of NIMCRUTs and things that we just talked about. There's tons of stuff there. I have a second website called Law Easy, LAWEASY, that has about 150 planning video clips. They're all about 10 minutes or less. So if you don't want to struggle through a broader, longer webinar, you can look for the video clips on Law Easy. There's probably hundreds of articles posted at this point onto Shankman Law as well that you should be able to search. So there's tons of materials, and I'm happy to make all that available, and hopefully it all helps you. And if there's something I haven't done that would be helpful, let me know and I'll be happy to do it. And ditto with charities. I've spoken and helped the American Cancer Society and lots of other charities all over the country. I mean, I think it's imperative that we all give back. There's so many people struggling, especially now, and I think it's going to get worse as the bonus unemployment runs out, that we all have to try to help out. So hopefully that will help everybody.
So Marty, for the people that did sign up and were on the webinar, their emails, I believe, are going to be available. So anybody that does want to get the slides, we'd be more than happy to send that to them. Several people have already emailed questions about the slides. So if you would like the slides, just let us know. Some of the people have also asked.
Still on the console. It's still on the console. Click the handout tab. You can download it right to your laptop right now. And if not,
Okay,
Brian will send it
perfect.
to you. But it is there, folks. We didn't hide it.
And then
Promise.
this will be recorded, because a couple people had mentioned too that wanted an associate to be able to join them for this, but that was not possible. So is that recorded one going to be up on your website, or do they need to email us? What from a procedural standpoint would be best, Marty?
I'll post it to my website, shankmanlaw.com, webinars by, let's say, Monday of next week. I will give you, Brian, and Gus, if he wants it, the recording, but I don't know what compliance issues that you may have. I fear that having the insurance credentials you do, that it's kind of like the Just Say No campaign. But if you can do it, you're welcome to have it, and you can post it as well. I just don't know if you'll have an issue. We have a big disclaimer on the front, and I'll add another disclaimer now for compliance, that everything here is for educational purposes only, and you should not take any action based on our general discussions. I should have said that in the beginning as well, but I'll post it for you to Shankman Law and send you a link so that you can circulate the link.
Okay. Well, Marty, I know you've spoken. You've got over 700 blogs, and you're quoted in the Wall Street Journal and many national publications. So on behalf of the American Cancer Society, on behalf of the Jones Financial Group, and the 60, 70 practitioners that we had, thank you very much for all of your learning today. Thank you for being available and as a resource. And I especially think it's critical, the team approach that you have advocated throughout your career, and again today on the conversation. All of us need to be relying and having others as a backup plan, and also to encourage clients, because left to their own devices, clients sometimes get something in their mind and it needs to be double checked and thought of. And it sounds like there's a lot of things that all of us should be going back to our clients, double checking, has things been updated, what's your net worth, have your plans changed, because there's a huge opportunity. So in closing, for anybody that's listening today, what would you say would be the next couple action items? Having invested 60, 70 minutes, what would you say would be the 1, 2, and 3 action items in close?
I think the first thing to do is to send a communication to all your clients, and with so many people still working remotely, dear client, the laws may change dramatically with the upcoming election. It's not worth the risk of losing this unique opportunity to plan. You really need to plan. It's not only about estate tax, it's about asset protection planning, income tax planning, and a range of other objectives. Call us and we'll help. I think you got to educate clients that they need to start taking action soon, because they're going to run out of time. When you do get any kind of communication back from the client, one of the first things we have on an intake form we have every client complete is, I want the list of the names of all their and contact data for all their advisors. And I try to get their accountant, and if they have a general practice attorney, and their wealth advisor, whoever's involved on their team, I want on that call if I can get them, because that's where I'm going to really get the information I need to do the planning and get it in a more efficient manner. So those are the two next steps that I think you have to do. And just for those that are practitioners on the call, one of the things that we started in January, because I remember living through 2012, our engagement letter, retainer agreement, billing arrangement, whatever you call it, we put a caution in that in January. So everyone that signed one this year, it says that if you get stuff to us too late, we may not be able to complete planning before the election. And we can't guarantee you what the effective date of any new legislation may be. We don't know what they may do. If the Democrats get enough control, they may very well pass something, in mid 2021 and make it effective January 1, 2021. And all the people that waited now because they thought they were going to outsmart it, not have to spend professional fees because they hate doing that, right? They may be out of luck. So we put that caution in, and you may want to do something similar in the documentation that you provide clients, so they're on notice that you can only do what you can do. So let's make a last pitch in closing for the American Cancer Society. It's a great organization. We've all had close friends and family die from cancer. I don't think anybody's immune. Join NPAN, National Professional Advisor Network. It's easy to do. It's just going to get you good free information. You just go to cancer.org/NPAN and you can sign up. They're not going to solicit you or bother you. They're just going to give you emails of great speeches and presentations. It's a great way to help a great organization. I think we're good, Brian. So, Brian, do you want to say goodbye? We're all set. Take care, everyone. Thank you for joining us.
Thank you very much.